this matter, initially, this was released by the division bench presided by Justice Khobarhub Chakraborty. Since his lordship's son appeared, personal ground will not appear. Now, thereafter, on 19 September, the matter appeared. Central government took time to take instruction. It was fixed on 11 November. Yes, what is the matter about? Matter, Millard?
May I intervene, with your lordship's kind permission? Because we have a preliminary objection. Before the appellant argues the matter and consumes your lordship's precious time, because there is a preliminary objection. If your lordship kindly comes to paragraph number 8 of the application, your lordship. There is an application which the appellant has filed. I am appearing for the National Highways Authority of India, my colleague is also present in court. If lordship may kindly, come to paragraph number 8 of the application. Page number 8, paragraph number 15, my lords.
This can application, madam. This can
application, my lords. Can number 2, your lordship is having.
Which of which? Yes.
15.
My lords, may kindly come to paragraph 15, that is at page number 8, my lords.
Yes.
My lords, the nutshell of his admitted position is that, my lords, the regular bench has already heard this prayer of interim stay for at least 1 hour before the courts were closing. And the prayer has been rejected. Very fairly, the appellant admits that my prayer for interim relief has... No, my lords.
Where is the order of 7th October? That is not in the lordship's way. I know my learned friend was.
Well, when the prayer has been rejected,
I respect your understanding. What allow me to speak? Is my appeal. I respect your understanding.
7th of October and today. The only difference is, Manoj,
and that the order of the 7th October, my lord. I have the copy, ma'am.
Sir, it is my appeal. Kindly allow me to speak. Sir, I respect your understanding and exuberance.
Sir, I am just raising a preliminary objection for consideration.
No. This, I know. You have presented it clearly, sir.
The only difference is
the strategy to influence the mind of the judges. We know, sir. Thank you.
Manoj, the only difference is that at that time, Manoj.
What is your objection? Preliminary cannot take up
this entire prayer for seeking an interim relief has already been turned on by a coordinate bench. Kindly see his paragraph. It is an admitted position. Kindly see the first line of page number 9. He admits that my prayer has been turned on by the coordinate bench. The only difference is that at that time it was an oral prayer and today it is coming through an application. But the prayer remains the same.
Oh, but are you having the copy of the order dated 7th October?
Yes, the order dated 7th of October says that we are granting him liberty to move before the division bench by making a written application.
Oh.
Yes, Manoj.
See, this was passed in Can 1. Now,
no. It was passed in the main appeal. It was mentioned by him. He says that my application has been turned down. He says so.
Sir, we are having the copy of the order dated 7th October. 7th October order was passed in Can 1 of 20. Obviously, any order in the application will read met with Can.
Can 1 and 2 are same. They both are having same identical prayers. First day. Can 1 is also first day, Can 2 is also first day. On 7th of October, the matter has been heard for 1 hour when his prayer for interim stay has been turned down, as admitted by him. No, my lords, what difference will it create today? It is just like, my lords, wasting the time of the Honorable Court. Your Lordship also hear it, my lords, I am saying.
No. Now we are minded to say you are wasting the court's time.
No, my lords.
You are making submissions beyond the record.
No, my lords, 1 and 2 both are the same.
Please, now listen. Can 1 was moved on 7th of October. can one in that application certain orders have been passed which include liberty to file appropriate application and pay for appropriate order. Now, has been filed on 8th of October and 2 was not there when the order was passed on 7th of October. So how do you say?
Because the reliefs are same. The reliefs of Can 1 and Can 2 are same. In both the application, the relief is same. In both applications, he is seeking a stay.
Very well. We have heard your preliminary objection. Let me hear now.
My lord, I beg.
RTC Miller, during the pendency of the appeal, the exuberance of the National Highway Authority Miller, the G+4 student building Miller, this has been partly demolished by applying Miller by taking the bulldozer. Miller, in this case, my case is Miller, the order passed by the learned single judge. Miller, I don't mind in having the matter heard, Miller. Mr. Basu, you were hit by a bullock cart. I am hit by a bullock cart. Because in this situation, you have the National Highways Authorities Act specifically provides of a mechanism for adjudication.
I'm grateful to you.
My unfortunate part of the story is, Miller, that neither of the parties, Miller, could bring or convince, Miller, the actual position of law. No. If you ask me, I am clear on this view because I am saying National Highways. I have not even placed, Miller, the facts of the case. Here, Miller, section 5 minutes. Section 3A notification for acquisition was made. Matter, all right. I did not challenge, Miller, the notification. Section 3E speaks, section 3E, 3G, 3H. There are 3 provisions. Section 3G, it speaks for determination of the valuation of the compensation. In this case, valuation was computed. Compensation was forwarded to the account of the petitioner appellant. He has accepted the money and he said without prejudice to my rights and contention, I is accepted with protest. Now, Miller, the 3H and 3E, it speaks about how the possession is to be taken and vacating of the notice. 3E mandated by of the Act, Miller, that a notice has to be given to the owner as well as occupier. Owner is, Miller, my client, my sister, who initially, Miller, moved a writ petition before Honorable Justice Miller, Honorable Single Judge. Miller, the notice was set aside on account of illegality and, Miller, vacating notice was given to her. Owner and occupier, such notice was not given. In this case, Miller, National Highway Act section 38, 105 says that the Resettlement Act of the 2013, it says that while computing, Miller, first schedule and fourth schedule of the Settlement Act 2013 has to be followed. In this case, admittedly, Miller, the document which is at page 115, this clearly suggests and shows admitted document that the mandate of Miller 2013 Act was not followed. The Honorable Single Judge says if you have a grievance, go to arbitration, section 3G, clause 5, it says so. My respectful submission before the Honorable Single Judge, I failed to pursue his Lordship's mind, Miller, judicial mind, that the Ministry, Miller, I relied on notification, 2015 notification, which I will place here before your Lordship, which clearly states, Miller, that a certificate has to be appended, Miller, while the computation has been made. Miller, to schedule 1 of the 2013 Act clearly says what are the ingredients and factors to be considered. The Honorable Single Judge was persuaded by the submission made by the central government. It's a public project. Central government and NIG authority, Miller, every day losing, Miller, this amount of money, astronomical amount of money, and citizens' interest cannot be allowed to be overridden the public interest. Miller, my respectful submission that the Ministry. This is where? NH12? Yes. NH12, 34, now 12. No, this is...
Near building, Pune Expressway.
National Highway 117.
117.
Pune Expressway.
117. It is taken up for the widening of 6 lane, my lord. No, maybe.
Kolkata to Howrah, my lord. Howrah to Kolkata.
These are the facts, my lord. No one can dispute. I am not disputing whatever with the proposal. After a full-fledged hearing,
before the single judge, how do you expect that an interim protection will be given
incidentally
without affording them an opportunity to rebut? Because see,
no, then I have to support the bulldozing of the entire premises, and when appeal will be heard after 5 days.
you have received the compensation.
Wow, my
lord, in the year 2023.
paltry compensation, 1 crore the property valuation government, 35 lakhs given, and she is smiling. She cannot understand, my lord, when my house is to be broken by an authority.
Not the,
my lord, it is, no. I tell your lordship. No. Your lordship,
both at a time.
my lord, your lordship is correct. I have no quarrel to, no quote to the proposition that the parties in the proceeding must be given opportunity. I said, my lord, respectfully submit that, my lord, interim protection. That I said, my lord, I have annexed the photographs. That during the pendency of the appeal, my lord, there was a time in the High Court, your lordship knows very well, better than I, my lord, that during the pendency of the matter when it is sub judice, the interference of any powerful institution, my lord, High Court deprecated this. There are instances. Today, my lord, I am before your lordship only to say that section 6 of the National Highway says that if any notification is issued by the ministry under section 6, whereby and whereunder the definite comment has been given, how the compensation certificate has to be given, whether this has been given or not. It is immaterial that my client has given rupees 35 lakhs. If the valuation of property is more than 1 crore and I am running a lodge, what is the object of 2013 Act, my lord? And what is the first schedule and fourth schedule? Fourth schedule says, my lord, that National Highway Act, it comes within the purview of this. 2015 ministry notification I am submitting, my lord. Only, my lord. There is a clear aberration of law. And due process of law and procedure established by law, my lord, have been violated. And even then, my lord, the National Highway passionately submits that I have been given compensation. Yes, you have given me compensation. I accepted it with protest. Kindly seize, my lord, clause 10, Joshua Kadichan. My lord, kindly seize the 2 paragraphs I will show. They are the powerful institution, they can bulldoze anything, my lord. Subpara 3.
My lord, if this is submission, my lord, my senior friend, my lord,
yes, I stick to my point.
Giving, my lord, 2 sisters, my lord, giving.
National Highway is not giving any. This is not absolutely right.
Very unfortunate.
You people are destroying citizens' right. Kindly seize the chain.
Test for it, my lord. They even not even annexed your lordship P4 without annexing, without giving me the copy. This is such type of desperation from their part.
What did there was 2 options. You go before the regular bench, no difficulty. Because see, this is not your residential house. You are running a lodge.
It is my bread and butter.
Maybe. No, it is not correct submission, my lord.
I am the owner.
Maybe. They are the owner of the second floor, my lord. It's a 4-story building. Whatever.
This is a sanctioned building.
No, there is a provision. I
do not seek any compassion and sympathy from your lordship. If it is my right, your lordship will
not under challenge.
It is not. Your lordship will reject my prayer. Wherever I will go, it is not for your lordship's concern. But kindly seize that if I can show and demonstrate. If your lordship says, due to paucity of time, your lordships are not minded to hear me, I am no problem, my lord.
That is what we are saying.
And in the meantime, they will demolish.
You have filed a writ petition.
My writ petition was hard. Exhaustively hard.
Yes, your writ petition.
When the judgment was reserved, his lordship granted a stay till the judgment is pronounced. Then, my lord, it was. Then I filed. I said, my lord, I have annexed certain photographs, my lord. Kindly seize that at least, my lord, give me a chance, my lord, to try my luck. Only, my lord, 2 days interim protection, my lord, kindly give.
My lords, may kindly see the impugned order of the single bench.
In a
20-page writ petition,
I want to show your lordship the mandate of, my lord, the schedule. No one has, my lord, produced till date, my lord, that what is, my lord?
They can agitate before the arbitrator.
No, I should not.
Come before the solemn court.
Some others, my lord, followed the statute. My lord, only my learned says.
Statutory aberration, my lord, kindly seize. I will not destroy your lordship's time. Kindly seize clause 3 and 4 and 5.
Without preparing any application before
then 5. Just 5. kindly cease 5. I am entitled subject to correction. Only 5 below clause 10. The CALA, while announcing the award under section 3G, shall append a certificate at the end of his award that he or she has strictly followed that legal provision and this guideline in determination of the compensation amount. Kindly cease. Milord, I am confident what I am submitting, that is the law.
That means that the possession cannot be taken. What? This sister is willing to give up the property, but the other sister has a problem.
I know the strategy. I know the strategy of the institution to prejudice. I know this kind of strategy.
All the adjacent landholders have given up the property. The project is going on in full swing.
The climate of the country. The CLA, while announcing the award of the crime, we are before a constitutional code for having a protection of a citizen. Clause 10, 5. The CALA, while announcing the award under section 3G, shall append a certificate at the end of this award that she has strictly followed the legal provisions and these guidelines in determination of the compensation of the amount. Then Milord kindly turns my page number 115. How they have, Milord, violated the law, Milord, with impunity, and I do not know where from this confidence comes from. 115. Smiling for a demolition of the house is a pleasure unknown to the humanity. 116. Take down. Look, Milord, kindly cease, Milord.
It can't be either you have to go before the regular bench or
regular bench. By this time it will be demolished, Milord.
Can't be helped.
Milord, kindly see the law, Milord. Kindly submit. I will be outside. Kindly give me 5 minutes time. 5 minutes time, Milord. Clause 10, 5 years.
Receive the compensation
to that. Please. No.
Milord, kindly 10, 5 your lordship has seen. Kindly turns Milord page 116. Kindly seize, Milord, and all the project. Kindly seize.
116 of which?
Of the application. Stay application can 1.
Can 1 has already been
Can 1 is a part petition, not disposed of. Part of the report.
That is the problem. This is the problem.
Will you please stop? Just because you are on virtual mode, you can go on interfering with the business.
I request your lordship.
The can 1, today we are hearing can 2.
Can 2 cannot be done.
Can 1
yes.
has been heard and an order has been passed on 7th.
Can 1 is the basis of the foundation, otherwise injunction cannot be taken up.
Mr.
Can 1 is not rejected.
Mr. Bose, you are making a submission where then we have
I am only intended
to sit on appeal over a coordinate bench order.
No, coordinate bench did not have the occasion to take note of this Milord. The coordinate bench, Milord, kindly have a charity to consider. Milord, your lordship at least appreciate the anxiety of a man, Milord, individual versus institution, imperial interest. Milord, kindly says that this, it clearly says 116, computation has been made. Milord, I am not following, Milord, this clause 5. I came before the lordship, then their lordship said that you are seeking injunction at this moment. You filed the appropriate document, so I filed it. Now because I did not have the Milord pictures, I then Milord on 8th Milord I filed this. Now Milord, अरे इंजंक्शनটা কিভাবে বলবো তাহলে?
We have spoken in between ourselves.
My lord,
we have spoken in between ourselves.
Yes.
If you are agreeable that you will not operate the lodge, then
আপনি lodge operate করবেন।
Melos may hear us also then. Plus we need the immediate possession. There is some urgency on our part.
My lord,
please hear us.
Operate করবেন না।
My lord, if that kindly allow us to place our case, my lord. My lord, no. My lord, that is the.
You place it on the timing.
My lord, that is the case, my lord. That is the case, my lord. Today, my lord, we are ready to with this matter, my lord. For judgment.
You are not ready to.
My lord, because of this,
undertaking.
Please appreciate one thing. In the year 9 October 2023, my lord, they received the compensation. After that, স্যার এতক্ষণ আপনি বলেন একটু বলতে দিন স্যার, হ্যাঁ একটু বলতে দিন স্যার, আপনার মতো আমারও এডুকেশন মাই লর্ড।
Is that good, bad, indifferent, he has come in an appeal challenging an order rejecting his prayer in a writ petition. Now today, details are to be balanced. It is correct that if you are prevented from taking possession of the land by demolishing the structure, your project will suffer. This is a public interest which is considered to be by the court of greater importance. At the same time, the petitioner has an individual has a private individual interest. He was part owner or owner of the property. Now he or she has received compensation without prejudice. Since we are in the vacation bench, we do not have the time. I did not mind. I would have on regular.
Because my lord, the situation is because my learned my lord.
A regular bench, if it had come, not at 4 o'clock or even in the vacation bench at 2 o'clock, we would have heard and disposed of the matter. But today we have to strike a balance. We have to send it before the regular bench immediately on the reopen. But if you by this time demolish the building, then nothing will survive for adjudication in the appeal. So we'll say 15th of November, the holiday, 14th of November, there should you should not demolish the building. At the same time, we will direct the local police administration and your authority to ensure that the building is not used for any commercial activity or for even residing purpose.
Malot, may kindly hear it, Malot. Malot, that is not what, Malot, there is extreme emergency on our part to take the possession. Kindly, Malot, bear us for 1 minute, Malot. 1 minute, Malot.
If you allow us, we provide the case for because
Malot, the regular bench heard can one was also for stay. The regular bench did not grant stay. There is a video recording whereby the regular bench has already heard the matter for 1 hour.
You don't repeat the same thing.
Then Manoj, kindly take on record certain Supreme Court judgments which we are relying upon. Which says that what will happen? Manoj, we are suffering from last 2 months. Kindly consider the adjacent land.
So other adjacent owners, other adjacent land has already been handed over.
The system is giving up the land.
The difficulty you are showing, your suffering. Let me tell you, where were you when series of acres of lands were not given to you in NH 34, which is NH? Where were you? Why did you?
Today the situation has improved considerably with the efforts of the court.
Under the National Highway Act,
We will have to go to the next court on Monday, Manoj.
the right over the property does not.
Manoj, what will he do of the property?
We are not for recognizing his right.
No, Manoj, what is Manoj, 1 minute, one last submission. Your Lordship has said that his issue of compensation needs to be decided.
You are appearing for whom?
Manoj, may I just take one last submission?
So you are appearing for whom?
For the National Highways, Manoj, along with Mrs. Roy.
They have a right to both speak. They are speaking.
Manoj, there is extreme emergency, otherwise I would not have speak.
Extreme emergency. Now you are, since Miss Ray is already before us physically, is making submission. You have taken your opportunity to stay at your house or wherever you are.
I am happy and
enjoying the vacation. So, and that does not mean that when she is speaking, then you come and make your submission.
I am down with viral, that is why I am not appearing.
Then
But Manoj, may kindly consider, Manoj, entire issue is related to compensation. What will the building do, Manoj? What will the building do, my lords?
See, I have clearly explained what is the intention of the.
My lords, please kindly bear, my lords, the regular bench has refused this prayer. My lords, building is needed.
We are not for the moment granting any injunction.
My lords,
We are saying that we are making this matter returnable before the regular bench immediately on reopening till say 4-5 days from the reopening. You should not demolish the structure. You and the local administration shall ensure that no one is in possession of the building, because the photograph shows that a portion of the building has been demolished. So no one shall be in possession of the building. No one shall operate it for commercial purpose, and at the same time, you do not demolish. If you demolish, then the appeal will become infraction.
no, my lords, no. His appeal is regarding compensation, my lords. He has admitted the acquisition, my lords. Kindly, my lords, consider this aspect. He has admitted giving up the building. He has admitted giving up the building. He wants more money. My lords, we will bear that.
Before that, my lord.
Kindly bear, my lords,
Both at a time cannot speak, and two persons representing the same client is beyond the decorum.
my lords, I leave it in my lord's hands. Extreme emergency, my lords.
Very well. Take down.
Status of the
Madam, may I submit? The notice has been issued or the state respondent. The notice has been issued by to the petitioner for vacating the premises. It's a 4-storied building, my lord. She is occupying one part of the second floor.
Mr. Bandyopadhyay, so your role is what?
But we have issued the notice. Previously, one notice has been issued similar upon the two sisters, Rumela and Pamela. Here the notice has been issued to the Pamela, but the
my lord, I know, my lord.
thereafter, my lord, it has been, my lord, set aside by the earlier coordinate bench. And as the honorable court, my lord, directed the respondent authority to issue the notice afresh upon the petitioner. Accordingly, this notice has been issued, and that has been challenged. Previously, they have accepted and received the amount without objection, my lord. And there is a provision of arbitration. They have prevented to prefer application. Other respondent, other the awardees have taken the.
I am aware of the provisions. I am aware. National Highways